here. Ms. Hill, I'd like to start with you, if that's all right. As you know, in 2020, in the McGirt case, the Supreme Court held that in unique circumstances, major crimes committed in Indian country can be prosecuted only by tribal or federal courts. This ruling removed the state's ability to prosecute those crimes in those circumstances. Now, you strongly support the McGirt decision, and it's important to keep in mind that in Oklahoma versus Castro Huertas in 2022, the Supreme Court clarified that states retain the authority to prosecute non-Indians who commit crimes against others, even if those crimes take place in Indian country. Now, in one of your many critiques of that decision, you called Castro Huertas, quote, a very negative decision. And you said that, quote, Kavanaugh's opinion, which of course was the opinion of the court, Kavanaugh's opinion, it was terrible. To justify that critique, you came up with a hypothetical in which you stated that, quote, a non-Indian steals a car from an Indian, and that person can be prosecuted by the state. That person can also be prosecuted by the United States. They can be convicted twice for the same act and serve 2 sentences. That was part of your critique. My concern is that your critique here demonstrates a fundamental misunderstanding of how the double jeopardy clause of the Fifth Amendment works. I think most first-year law students can tell you that double jeopardy prevents separate prosecutions for the same offense when those prosecutions are brought by the same sovereign. A non-Indian who steals a car from a non-Indian, for example, in Utah, is properly subject to prosecution by both state and federal authorities, by the state government and by the federal government, because they are separate sovereigns in our system, just as in any other state in the United States. State governments are unique. They are unique independent sovereigns, separate and apart from the federal government. And the federal government is a completely different sovereign. This has been a line of authority. This has been a principle that's been clearly established ever since our nation's inception, certainly ever since we adopted the Double Jeopardy Clause in 1791 as part of our Constitution. So yes, McGirt presents a unique set of circumstances, an Indian committing a crime against an Indian in Indian country. But nothing in the Constitution prevents a state from prosecuting a non-Indian for their crimes, regardless of who the victim is. So in your view, do you disagree with the characterization of double jeopardy as I've just stated it? Do you disagree that the states are separate sovereigns from the federal government for purposes of the Double Jeopardy Clause?
I certainly don't disagree with that.
And if confirmed, would you follow the majority opinion in Oklahoma v. Castro Huertas?
I absolutely would. And given the practice that I've had, I've been following it for some time.
Your apparent desire to remove the state's authority to prosecute non-Indian offenders would, in my view, only weaken law enforcement's ability to remove violent offenders from the streets. And it's dangerous to place loyalty to any particular group over your loyalty to long-established principles of law or of the Constitution. So am I misreading your statement regarding Castro Huertas or the hypothetical?
I think that the full context maybe is not really reflected there, the full context of my comments. I can say, certainly on behalf of my client, I was critical of the decision in Castro Huerta because it was a decision that had other ramifications in Indian law outside.
Right, but I'm not talking about the other ramifications. I'm just talking about about double jeopardy here.
Right, I understand that. But those ramifications, that was some of the context of my criticism of it. I certainly believe and understand that I'm required to will be required to follow the law if I'm so fortunate as to be confirmed to serve in the Northern District. And I understand the distinctions that if you have 3 sovereigns, that all 3 sovereigns could bring those claims, and there would not be a double jeopardy issue.
Okay, while you were while serving as Attorney General of the Cherokee Nation, did you state that you had no intent to enforce the law post-Dobbs?
I never said that.
Did you at any point say, I expect, and I think everyone expects, massive constitutional challenges to that law, just for your awareness, referring to those laws?
I was not referring to Dobbs. That was the decision of the court. I was talking about the Oklahoma law that had been passed relating to abortion post the decision in Dobbs, and that law was being challenged, had already been challenged in the courts. It was significantly newsworthy in Oklahoma at the time that the Oklahoma law was being challenged.
Challenged post-Dobbs on grounds that you believed were legitimate challenges post-Dobbs?
I couldn't say that they were legitimate. I just knew that there were likely to be many challenges to it. It was very contentious.
Okay. See, my time's expired. Thank you, Mr. Chairman.
Thank you, Senator Lee.